Operations Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Listner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on best practices for processing and managing issue fee payments and notices of allowance. The Operations Excellence webinar series is free. This is the 5th webinar in this series. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover best practices and processes for managing notices of allowance, issue fee payments, and continuation decisions. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, but that question will be held in a queue until the end of the presentation where we take the questions. The presenters today are myself, Peter Rebafoni, and Joni Smidas. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Peter, can you tell the audience about yourself?
Absolutely. Thanks for having me. My name is Peter Rebafoni. I have been with the Schwegman firm in Minneapolis for 15 years and working in IP law for 17 years. And I currently manage legal operations for the firm.
Thank you, Peter. Joni, can you tell the audience about yourself?
Yes, I work for Caterpillar, Inc. I've been employed for Caterpillar for approximately 25 years. My current role is business process supervisor for the patent operations team. And I've held several roles in docketing, agreement paralegal, foreign filing, several roles over my tenure with Caterpillar.
Well, Joni and Peter, thank you very much for being a part of the program today. I'm going to start us out, and I know for most of our audience that this will be background, but we do have a wide range of people that attend these webinars, so I do want to set the stage. Let's talk first about where a notice of allowance occurs in the overall patent prosecution process. Typically, your patent prosecution cycle includes, obviously, starting with filing an application. You may only have a restriction requirement, and then you'll have a non-final office action or a final office action after that. You'll file some number of responses to those non-final office actions and final office actions. Eventually, the application is hopefully allowed, or if not, you may decide to abandon the application, or you may file an RCE or some other type of continuing application. So that's a very generalized view of the overall process. Next, what are the requirements when a notice of allowance is received? Again, this is background for a lot of you, I'm sure, but just let me walk through it briefly. There's a number of things that may need to be addressed depending on the context. If you have a missing oath or declaration, that will need to be filed before the issue fee is paid. If there are any drawing corrections that need to be made, those need to be addressed, or other formal requirements that may need to be attended to. And one of the key things that often comes up that may be problematic at this point is dealing with prior art that still needs to be cited, either because it just hadn't been cited yet at this point or it was recently received. The process around tracking and determining if there's prior art to be cited is something that's a key part, I think, of most people's processes at this point. Obviously, then if there's an examiner interview summary, that would need to be submitted. And then the big thing is the payment of the issue fee, which is due 3 months from the mailing date of the notice of allowance. And then prior to the actual issuance of the patent, the decision needs to be made with respect to filing any further continuation or divisional applications. So from an operations standpoint, those are some of the requirements that come up that may need to be dealt with at this point in the process. There's a couple of other things that we're not going to talk quite as much about, but I do want to mention them that also may come up at this point in the process. Optionally, you may have a situation where you want to file or need to file a 312 amendment. Typically, these are filed to correct typographical errors and clean things up at this phase. I mentioned continuations or divisionals on the previous slide. And sometimes, instead of paying the issue fee, you opt to file an RCE to continue prosecution. And that typically comes up in the context of a scenario where you have prior art that needs to be cited. So before we get into the operations aspects of notice of allowance, let's talk briefly about the docketing requirements. The core docketing requirement is obviously to get that 3-month deadline to pay the issue fee on the docket, and that's a non-extendable deadline. Some other things that organizations may docket, depending on the circumstances, is you may docket a 1-month deadline from the mailing date of the notice of allowance to review for prior art, like I had talked about. Also, you may docket a 1-month deadline for any formalities, oath declarations, sequence listings, anything like that. It's a good practice to docket a deadline for filing the continuation and divisional application. And some people will also docket a reminder to check for receipt of the issued patent after the issue fee has been paid. So let's just look briefly at what some of those docketing entries might be. Here's a few examples of actual docket entries, and these are taken from, I believe, a typical foundation IP system. The descriptions might differ from system to system, but I think the concepts here are good. So typical entries that you may have would be, you might have a 2-month deadline from the allowed date to docket a continuation or a divisional decision. You may have, well, you're definitely going to have a 3-month deadline from the allowed date to pay the issue fee payment. You may also have 3-month deadlines from the allowed date for formal drawings, if formal drawings are due at this point, or to submit a declaration, if a declaration is due at this point. Also, again, depending on the context, if there's a need to file a response to an examiner's amendment, you docket a 3-month deadline from the notice of allowance date, or if you intend to file a response to the examiner's reasons for allowance that are in the notice of allowance. Again, docketing a 3-month final deadline from the allowed date for that. And then finally, this one's a little more optional. Some people will docket a deadline to check for the original letter's patent received, and that is fairly arbitrary. It could be 6 months from the allowed date, just something almost like a status check in a sense. It's just something to keep that out there to remind you to make sure that you did get that original letter's patent. So I want to focus in this program more on the operations aspects than the docketing aspects. We're going to be talking with Peter and Joni, and I'll share some observations as well about what we see in different organizations with respect to the operations aspects around a notice of allowance, both looking at what some law firms do and what some corporations do. So my next 2 slides are just generalized workflows, but then we'll talk more specifically with Peter and Joni sharing some specific examples in the law firm environment and the corporate environment. But at a high level, if you think about what the typical law firm workflow would be when you have a notice of allowance, there's going to be a requirement, obviously, to report the notice of allowance to the client or the outside counsel. There are likely some administrative tasks that might be docketed as specific docket entries on a staff member's docket. There are likely some substantive analysis tasks that may get docketed on the attorney's docket. And then obviously the process to report and assemble the notice of allowance according to the docketed process. Then verifying, at this stage often you'll be verifying the list of inventors is correct in view of the actual allowed claim set if the claim set differs from the way the claim set was when the application was filed. Law firm will need to obtain instructions for paying the issue fee to confirm that their client is authorizing them to do it. Then the law firm will typically pay the actual issue fee, although some companies will take over at that point and handle the payment themselves, even though the law firm prosecuted it up to that stage. And then the law firm will also need to file any required continuation or divisional applications. So that's a typical set of workflow steps for a law firm. Now let's look at a typical set of workflow steps for a corporate IP department. In that context, when a notice of allowance comes in, usually they're going to be receiving a report of that notice of allowance from their outside counsel, unless they've prosecuted it internally. There may be a need to have a phone call or a meeting with the attorney at the law firm handling the matter to discuss the options, or they may just provide written instructions to the law firm. There may be internal meetings with the executives of the business units to discuss the options at this point. Many law firms have to do this within determined budget constraints. And after a decision is made and the budget projections are made, there may need to be a process to get expenses authorized. And finally, the corporation, if they are not paying the issue fee themselves, will be authorizing their law firm to go ahead and pay. Another thing that comes up on the corporate side is that the in-house IP counsel may also be evaluating the claim set just to make sure it still meets the strategic goals of that application, or it covers a particular commercial product that it was intended to cover. And if not, these things may be guiding the in-house counsel as they decide whether or not to file a continuation, for example. So those are some of the high-level general workflow steps. Now let's get into some specifics, and I'm going to start with Peter. Peter, can you talk about the checklist and processes that the team you supervise follows?
Yeah, absolutely. Obviously, this is just a pared down checklist of the number of things we review upon allowance. Typically, once we're done celebrating that we got a allowed matter, we will make sure that all the formalities have that indicated on the notice of allowance have been docketed appropriately, and that we put in motion internally any steps to, gather missing inventor signatures, prepare formal drawings or corrected application papers. Second step would be to review the allowed claims, make sure the claims as indicated in the notice of allowance by the examiner are the claims that we last amended. It doesn't happen often, but sometimes the claims that are allowed or as indicated as allowed, the examiner was looking at the wrong claim set. A next step would be to see whether or not anything has changed at the company regarding the size of the company, a licensee, a new assignee of this IP. This is really important because the PTO doesn't require every time we pick up a case to verify the entity size, but at payment of the issue fee is the first time after filing the application where we have to make that determination. So it'll affect fees, it'll affect things going forward. So that's a really crucial step, is to check with the client to see if they've now if they were a small entity as filed, whether that small entity status still applies. Obviously, checking all the SB 08 or 1449 forms as supplied to the examiner have been initialed and returned. Look to see whether or not there's any other art, maybe from a co-pending case or a foreign matter, that still needs to be sent to the examiner. Perhaps an RC applies here or something to get that in front of the examiner. If you claim to a foreign priority case, have certified copies of all those priority applications made it into the file wrapper and made their way to the examiner for consideration. And then one that we also look at is, now that we have allowed matter, is there other PPH opportunities in any co-pending cases, maybe foreign cases where they have PPH programs to basically track this co-pending case.
So Peter, that's a great list. Is this list the paralegal list? And the reason I'm asking that is this PPH item on your list, is that a check done by the attorney, or is that a check done on the paralegal list?
At our firm, there can be a fair amount of overlap between what's a paralegal item or legal assistant item and what the attorney items are. Typically, we would put most of the formalities and obtaining formalities on a paralegal or legal assistant, and something more high level where a client needs to be approached regarding entity size or strategic goals here would be an attorney checklist item.
Okay, so what you've got here is a mix of things that could be attorney, could be paralegal. This is not just exclusively the paralegal checklist.
Correct, and a lot of these things may be a two-step checklist where a paralegal may flag this case as being maybe a co-pending case is PPH eligible, and then they'll forward that on to the responsible attorney to see if they agree and if they are going to bring up that opportunity with the client.
Okay, good. Do you want to talk about issue fee payments next, or should we keep talking about notices of allowance?
We can jump ahead. I guess we'll come back to the allowance.
Okay.
So, a fair amount of time can go by. You could stretch the entire 3 months between receiving notice of allowance before you go to pay the issue fee. But so things can trickle in between when you first looked at the allowed case to when you are gearing up to pay the issue fee. Additionally, sometimes we may have instructions from a client that they want to expedite payment of the issue fee. So there could be a very short window here between when you get an allowance and you need to make payment per client instruction. So there's things to be looking at. And a lot of times this is the same list as when you first received the allowance, but for instance, have you had any examiner interviews since then, or was there an examiner's amendment in the allowance? And when you go to pay the issue fee, this is your last opportunity to respond to those. You can, with either comments on reasons of allowance or an interview summary. If you have corrected application papers, formal drawings, and you make sure that if those were called out as needing to be formalized, that you file those concurrently with your payment of the issue fee. One item here that's absolutely important, and everyone here probably has seen this, making sure that all inventors' declarations are filed now under AIA with the issue fee payment. Absent a complete inventor's declaration and any of the corresponding information that's required on the ADS, absent that, you will get an abandonment, and that's something we absolutely want to avoid. So, when you go to pay the issue fee, you will want to make sure that not only are all those signed declarations in hand, but all the information that you supplied for the case on those inventors hasn't changed at all. Otherwise, it could result in the PTO seeing the discrepancy and just sending you a notice of abandonment. And one other item, if most firms are not in the business of handling maintenance fee payments, a lot of clients handle those themselves, or third-party vendors may handle that as well. So if you're going to redirect the PTO regarding fee address, now's the time to supply them with the customer number of the law firm or the client that'll be handling maintenance fees going forward.
Good. Okay. So that's a good list that's, I would say, universally applicable to all the clients at the firm that you're at. Some law firms have individual clients with individual requirements, special reports or processes that they follow above and beyond the general process that they follow with respect to a notice of allowance. There's one firm that I've had some interactions with recently. I'll just describe them as a medium-sized IP firm, prosecution boutique, but medium-sized. And they have a client that requires them to provide a notice of allowance report every time they have a notice of allowance. And that report is fairly informal in terms of the way it's structured, but it walks through the prosecution history, basically, and provides a summary of all the events in the prosecution history, highlighting the things that in particular affected the claims. So, for example, it might have a format where it lists the title of the application and then the date and the item filed. So let's say May 16th, 2015, filing receipt received, May 18th, 2015, IDS filed, and so on. When it gets to items where there are claims involved, they'll also note if claims were amended or canceled. So the client can look at this very quickly and see the changes that happened to the claims during the prosecution. They also, in their form, tend to also note when IDSs were filed and if the IDSs were considered by the examiner and when. So it's just a high-level, very informal, but typed in a Word document, but free form, not structured, summary of what happened. And then in addition, they also provide to their client a snapshot of the screen from the USPTO's assignment database showing the current assignment that's on record to confirm that the assignment to the client from the inventors has in fact been recorded. And then any particular things that may be odd or unusual are also noted. This is for them a maybe 2 to 3 page Word document on average that they prepare and provide as a report to their client with every notice of allowance. That's one example I've seen. Peter, do you have some examples of reports from some of the clients that you work with?
Yeah, we have a variety of reports that may go to a client, and a lot of the information you just described, the prosecution history, the allowed claims, list of inventors, are items we'll send to them. They may also be interested in the division that this application originated from, maybe the technology summary or the product description, things that help them identify readily what this case is, exemplary figure. And that varies by client, but I think from an operational standpoint, because a lot of these reports need to go out the door to a client so they can make some decisions, you have to sort of build in a timeline for that to occur, not just preparation of a report, but also to give the client enough time to actually look at it. So that may include, creating checklists for client-specific checklists for your paralegal or your attorney, templates for these reports that the clients that contain the client information to be generated, and even docket dates for both sending a report to a client and for following up and getting instructions.
Oh, that's a great point. So you might docket a 1-month date from the notice of allowance to send the notice of allowance report to the client and maybe a 2-month date to follow up with the client for instructions.
Yeah, that's a great example. And everyone at this stage has a lot to consider. And all of us want a lot of time to sort of get everything in place. So the client may need a lot of time to make some of these decisions, and we want as much time as possible to make sure when we file the issue fee payment, we have everything in order.
Sure. Well, let's change hats now and look at things from the corporate perspective. What happens when a corporation receives a notice of allowance? So I'm just going to talk about an example, actually a paralegal I had hoped to have on this panel, but she wasn't available today. She works for a medium-sized corporation in the Midwest. They have 7 patent attorneys and only 1 paralegal. They internally use Foundation IP as their docketing system. They use outside counsel to do all of their prosecution, including payment of the issue fee. So for them, their process is they receive the report out from the outside counsel that the application is allowed. And because there's only 1 paralegal, that particular paralegal can't do a lot of things at that point, and that paralegal's primary focus is making sure that their Foundation IP system is set up with the correct information for annuity payments because, and Peter, you mentioned some clients take over the annuity payment process. This particular company does. Their outside law firm does all the prosecution, but they take over the annuity payments. So the primary process step for this paralegal at that stage is to make sure that they have the correct information in their Foundation IP system to be able to pass it over to the annuity vendor that they use to set it up for proper payment of the annuities. They have standing instructions based on a tier level that's assigned to the case at the time the application is selected for filing that help to guide some of the other decisions on the part of the attorneys, like whether or not they would file continuation applications or not. And I know there's a much more detailed process that the attorneys follow, but just focusing on the operations process in this scenario for that paralegal, it's primarily centered around making sure the annuity payments are set up. Now, Joni, I know Caterpillar has a much more involved process for notices of allowance. Can you talk a little bit about the internal process when a notice of allowance comes on a Caterpillar case?
Yes, the distinct difference, there's a lot of the same checks, and I'll talk about those a little bit, similar to Peter's, but the distinct difference is as a corporation, we've instructed counsel that after the notice of allowance is received, that we'll take over everything at that point, everything meaning the payment of the issue fee, and we may have counsel file a continuation or divisional, but we will make that decision internally. So when the notice of allowance is received, the first thing we do, of course, is docket the due date for the issue fee for 3 months, the payment of the issue fee, but we also docket a 2-month date for the final fee checklist due date. And the final fee checklist consists of a couple sections. One is for the attorney to review, and one is for the paralegal to review. And the paralegal reviews their section first. And a lot of the same checks are included that Peter talked about. We look for if there's an agreement or government contract, if drawing corrections are needed. We look at the assignee name and make sure that it's the same in pair in our patent system. And in the assignment documents, we look at whether there are any additional references to be cited. Also, we review the foreign cases to make sure that there's no additional cited art that needs to be noted. And we also review the DMS, our electronic document management system. We make sure we check that for completeness and accuracy to make sure that all of the official file, similar to PAIR, is included in the patent folder in that. Those are the paralegal duties, and also to look at the claims and to make sure that those allowed claims are noted and the non-elected claim numbers and the claim numbers for the allowed claims. The attorney's review is very similar to what we've already talked about. We look for design changes and production status to see if those have changed. We actually have a strategy and prime product designations that they review at that time. And let's see, the PPH opportunities to make sure that those have been considered, and the Rule 312 amendments, and then the need for a continuation of CIP or divisional application, and any relevant third-party agreements, or have the examiner's comments in the notice of allowance been reviewed for potential concerns. And then their ultimate check is pay the issue fee or not, and then does the change of address need to be completed, which we do in almost every case, because we are responsible through a service provider for the maintenance fees also, and we want any correspondence after that date. So we have this, the final fee checklist comes out on the attorney's U.S. docket report, and on the paralegal report, they follow the attorney's report. So it is a due date that, in fact, it's the only non-official due date that exists on that report, I believe.
So you don't typically docket internal, what I would call process steps, but in this case, the final fee checklist is a pretty important part of your process, and that actually gets a 2-month deadline docketed in your internal docketing system, correct?
Yes.
Now, can you give the audience a little bit of context, like, for example, how many attorneys are in your department, or how many U.S. paralegals that are involved in this type of a process, to compare that to the first example with the medium-sized company with 7 attorneys and 1 paralegal?
Yes, currently there are only 3 U.S. paralegals, and there are approximately 15 U.S. patent attorneys. We have several global offices, but as far as the U.S. is concerned, we have approximately 15 attorneys dedicated for U.S.
Okay. And then again, going back to some logistics questions, when that notice of allowance comes in, who initially generates this final fee checklist? How does that process get kicked off?
It is set up in our patent system. It's set up as a form, so it's a merged Word template. And so the paralegal will generate it from the system to pull the pertinent information into the form, and then the paralegal routes it. It's got a routing on it. It's routed electronically, so each person checks off when they're done with their review. And then it goes ultimately to the U.S. docket clerk for payment of the issue fee.
Okay. Well, good. Thank you for sharing that. I appreciate that. I've got one other example from the corporate world that I can share, another company that I've been involved with. This is another medium-sized corporation. They have several internal paralegals and attorneys, and they do a portion of their prosecution internally, and they pay their issue fees internally. So their checklist and process for handling a notice of allowance is very similar to Peter's and has overlap with the Caterpillar process as well. They're looking to make sure the file is in order, basically. So they're checking inventorship, they're checking the applicant information, checking declarations, making sure the title's correct, looking at priority claims, making sure all the drawings are in order and formal, looking at the allowed claims, making sure the list of the allowed claims is correct on the notice of allowance. And one thing you guys haven't mentioned, Peter and Joni, that's on this checklist that I find interesting is they do a review for restriction requirements. So if they have a family of U.S. matters that have had a restriction requirement at some point in the process, part of their notice of allowance review is to walk through all those family members and determine if there are any unelected groups of claims that have not yet been filed on. They're afraid of leaving something on the table and missing out on one of the non-elected groups of claims based on that restriction requirement. So that's an important part of their review process. They also review when they're going through that family history to see if there had been any terminal disclaimers filed as part of the process in any of the prior applications as well. So those are a little different than some of the things you guys had mentioned, and I just wanted to provide that as an example as well.
Yeah, and anytime we can bring to a client's attention some non-elected claims for a possible divisional application, that's also something we try to do. And that's something that clients want to know right off the bat is, do we have any claims that we, previously canceled or withdrew?
Mm-hmm. Yeah, that's important. So this is the point. Having that as a actual step on a checklist helps to avoid missing something like that too, whether you're a law firm wanting to make sure you're providing the best service you can to your client, or you're internal and you're just making sure you haven't missed anything.
It just occurred to me, we also have a client whose default process is to RCE every allowed case to try to get broader claims. And that they don't even pursue a continuation until they've tried at least one time to RC and get more claims than we've already gotten.
That's really interesting. I have not heard of that before.
Yeah. So every client is different, and some want automatically to file a continuation, and some want us to just resume prosecution.
Interesting. All right. Well, let's see. We've talked about the issue fee payment checklist. Peter, you talked through that. I just want to comment very briefly on the use of analytics where analytics are available. Anytime you're making a decision, and the decision to file a continuation is a big decision point for a lot of people, any particular data that's available through public sources or commercial fee-based sources is always useful at that point in the process too. And some law firms are using that type of analytics data to make recommendations to their clients. Some law firms are even providing information like that as part of their service to their clients. But that type of information is out there as well, and I just want to mention that. At this point, I think we'll take a look at questions. We have a few questions in the queue, so let me see what we have. 1 second here. And I just want to remind everybody that you can submit a question with the question box on the right-hand side of your browser. Let me take a look and see what we have for questions. Okay, what is the latest timing to file CIPs or divisionals after notice of allowance? Is it before payment of the issue fee or the actual date of patent issuance? Peter, I'll turn that one to you.
It's a great question because we talked about the importance of docketing and filing any continuing applications. Typically, so the last date, and I think Ann mentioned this already, to file any continuing applications is on the date that your case issues. How you docket that varies, though, by law firm or by client. For instance, we have in our system the default date set up by the case management system dockets off of the issue notification. And so once that issue date is set, it'll docket that as the deadline for filing any continuations and divisionals. We have an internal date that we've also launched that is not reliant upon the issue notification, but is based on when the issue fee payment is made. We will docket for a week after payment of the issue fee to get any continuations, divisionals, CIPs on file.
So just to help the audience too, you're using a Foundation IP system. So if anybody else is using Foundation IP, and you're saying that the actual ConDiv due deadline that's launched by Foundation IP triggers off of the issue notification received. Is that correct?
That is correct.
But because there's always a risk when you're that close to issuance, or even there's a risk that maybe you don't even get that issue notification, the firm is docketing a ConDiv reminder earlier in the process that's a week after, you said a week after payment of the issue fee?
It would take record timing by the PTO to turn around our payment in a week to issue the patent, and we haven't seen that yet. Hopefully, we always have a little time there. But I think one of the concerns, and I think everyone on this call probably shares this, when you push something off to the last minute, you never know when electronic filing may be down or something, or there's a scramble to the finish line. So we try to create an internal docket that supersedes any default dates that, in our case, Foundation IP applies.
Is that one last question, because I'm interested in this earlier date that you docket for the reminder. If it's 1 week after the issue fee payment, do you put that on the docket at the point that the notice of allowance comes in?
No, we don't.
So you wait till you pay the issue fee.
Because, a lot of times just because you got a notice of allowance, like the example I mentioned where the client by default files an RCE, you're not necessarily sure that, that's when you need your continuation divisional. And then one other thing we didn't really discuss is, a lot of times we're watching from the point of allowance until the point of issuance to possibly withdraw from issuance to including the additional art that may have come to our attention. So in that case, if you apply a continuation date, a lot of times you may just have to clear that date only to docket a new continuation date when circumstances change.
That's interesting. Okay, thank you. That's really helpful. Joni, this one's directed to you. It says, Joni, you said the issue fee eventually gets sent to the USPTO clerk. Do you pay the issue fee at your corporation by EFS, electronically, or through actual postal mail?
No, we pay it electronically.
Okay. Okay, so you guys are paying electronically.
Yes.
Here's a question, and Peter, this is probably directed to the law firm. Do you report to a client the date when a patent issues?
Yeah, I think typically that a client's going to receive from most law firms the issue notification when that issue date is set. We have subsequent reports when maybe we've confirmed the patent term adjustment numbers and verified an expiration date. And also when an OLP comes in, which will be after the issue date. But I think typically most firms are going to tell their clients about an upcoming issue date multiple times before you actually hit that issue date.
Okay. Here's a great comment. Why not file a quick path IDS instead of an RCE to submit any missed references?
I believe, sorry,
you want me to jump in?
I'll take it.
I'm looking at you, but I didn't say Peter. Go ahead.
No, I think the QPID only applies after the issue fee payment's been made. So, a lot of times we might RCE after allowance when we have pertinent art and we are before payment of the issue fee.
Yeah, that's a great point. But for any of our members of the audience who are not familiar with the Quick Path IDS program, it's a pilot program at the USPTO that's a great program for that scenario where you're very, very late in the process and suddenly you become aware of new prior art. Typically, that's going to come in from a foreign search report or a foreign office action. There's a mechanism that allows you to potentially have that art considered by the examiner without having to file an RCE. But again, I think it has to be after payment of the issue fee.
Right. And I think there are requirements around QPIDs, and not all of those, as far as when the art was received. So not all those always apply. So sometimes, unfortunately, you're left to RCE and not do a conditional RCE with a QPIDs.
Yeah, and there's also some timing requirements, and this is a comment somebody else just sent in, and I'll share the QPIDs, the Quick Path IDS, so we shorthand that QPIDs, but we're not talking about little guys with hearts and arrows at Valentine's Day. The Quick Path IDS is only valid for art that you received within the last 3 months too, because you could also be in a situation where you had it and you can't actually certify that you only recently received it. Otherwise, you would have to file an RCE to have that art considered. So it doesn't always apply, but when it does, it's a great program just for you to be aware of if you have not utilized it. And I think it's becoming more and more utilized. I have a couple more questions here. Can I get a copy of the slide deck, and will this webinar be available to listen to at another time? Absolutely. The slides and the audio recording will both be posted on the Black Hills IP website under the Educational Resources tab, and then under the Operations Excellence section. And give us a couple of days to get those posted, but then they'll be available to listen to on demand. So please share them with anybody else who might be interested who couldn't make this program. And then the final question we have is, do you have a sample checklist you could share? Unfortunately, a lot of these checklists that I have laying in front of me are confidential client or customer information for Black Hills IP, and we can't provide that to you. We did try to do our best to generalize some of them with those last couple of slides that we had on the presentation itself, with some of the general things that would be in a checklist for notices of allowance or issue fee payments.
And those seem to touch on most of the high-level items you will want to be looking for. A lot of the checklists that at least we have are database specific as well.
Right. So those are good high level to make sure you get the right things addressed in your checklist, and then you can customize it to your particular organization and your particular system that you're working in. All right. That's all we have for questions, and we're actually getting towards the end of our time. I just want to announce to the audience that the next webinar in the operations series will focus on certificates of correction. That's in about a month. It's on April 25th at 1 p.m. Central. So I hope that you can join us for this upcoming webinar and other webinars in our series. Thank you very much. Thank you, Joni and Peter, for sharing today, and thank you to the audience for dialing in. We appreciate your time. Thank you, and have a great day.